Hey guys, give me some 5x5 so I know I got comps here. So today's going to be kind of a short day for me with you guys. I'm headed to stand by. Let me just get this lock off of here. So I'm I'm attorney Mike Ehline. I'm a lawyer licensed in California, Texas, and my background is appellate law, criminal defense, civil rights, and modernly I do work comp as well as personal injury law to provide for my family, but I still am heavily involved in Second Amendment rights, First Amendment, Fourth Amendment, civil rights law, but primarily with a focus on bodily injury. And that's just to give you an idea of my background. I've been practicing law for about 20 years, and I'm really, really concerned about the digital age and the modern police state. It's just gotten worse and worse and worse. And so many law enforcement officers have decided that they're going to be law enforcement officers instead of peace officers. And so that's always been a problem for me. Being a former Marine and someone who took an oath to uphold the Constitution, I grew up in an era where they actually taught the Constitution and the Bill of Rights in the public school system without couching it as though all of our founding fathers were evil, white, racist slave owners. They actually taught the history of what really happened. And so we understand that they were purchased from black people who were slavers. And if you want to hold white people, less than 1% of the population held slaves, accountable, then it would make perfectly good sense that we would trace it back to the original black slave owners and call them racist, bigots, and homophobes as well, and make them pay their so called fair share. So I have a different view of history than what's taught in the modern Marxist run so-called education system that was imported here by the Rockefeller family in order to create a nation of workers and not of thinkers. So just to give you a little bit about my background, I think outside the box compared to modern so-called scholars, and I don't have a lot of faith in the modern education system. I don't think that a degree in underwater basket weaving that leads you to a job at Starbucks is the way to go. So I homeschool my kids, and I believe in creating parallel systems with people who are capable of critical thinking. And critical thinking is not something you're born with. Critical thinking is something that you're taught, typically by a two-parent family, but with a strong father figure. So just for those of you who want to argue that, oh no, you're born knowing how to be a good salesperson, or you're born knowing how to critical think, that's nonsense. You're born with an IQ level and a processing speed that makes it easier for you to do those things. But without leadership and training, you're not going to do well. When I first started in sales, I had a great personality. It helped me. But it wasn't until I started reading books by Tom Hopkins and Tony Robbins and Zig Ziglar and listening to tapes by Norman Vincent Peale, it wasn't until I learned the tactics that I became number one in sales. So hopefully you guys are hearing me. Hey, Jody Shiloh, good seeing you. So we're going to talk a little bit today about modern policing in the digital age and the the schism in how courts and modern law enforcement have used. Sorry, guys, I've got a little bit of an allergy problem today. I'm out in Summerlin and it's been raining on and off. Along with this heat, it reminds me of being back in Maui. So it's kind of weird. I always kind of have this congestion in the morning, so just bear with me. Um, so when I was first starting to learn law back in well, a long time ago. There's a case called Smith versus Maryland. It's a 1979 case that said you have no reasonable expectation of privacy in data shared with third parties. So phone numbers and anything that you share over a phone line, that you have no reasonable expectation of privacy. Basically, in a nutshell, that's kind of how it worked. And obviously, to First Amendment purists such as myself, I realized then that we have a real problem with these politically appointed judges because after they've spent most of their life in government indoctrination in the school system, they're going to be much more akin to being like the communist Chinese. Whatever the government says is what we'll go along with. And you see that in modern courts today. They typically go along with the government and the state. And obviously, who writes their check, right? Whose name is on their paycheck? It's not we, the public defenders of the United States. It's we. It's we, the city of, the county of, the government of, the state of, the country of, even the even the even the public defenders are getting paid for by the state. And I found that prosecutors and public defenders, once you get them out in a bar and they're hanging out together, their philosophies are indistinguishable, in my opinion. The vast majority of them are, they basically think that you're guilty until proven innocent. That has been my experience. Give me a bunch of ones if you agree. So, anyways, I'm just headed to the gym. There is a party that they're throwing at Powerhouse Gym in Las Vegas. I'm going to go train, and I'll try to shoot some video for you as well of the actual party. Good seeing you, Michael. Good seeing you, Tom. Glad you guys joined me today. Life Under, if you're still here, good seeing you, brother. So I know that topics like this aren't super popular. You guys like watching cops spit on people and chase them around and get crazy, and that's wonderful and everything. And I know that my channel probably suffers because I don't do as much of that anymore. Because I'm hoping that I have enough subscribers now to where I can start building a parallel system with the critical thinkers that watch my channel. So today we're going to talk a little bit about police surveillance and government surveillance. And if you watched my my Snowden video the other day, I did a Snowden video where I kind of got into it more deeply at my office about how people are saying Snowden is a traitor because he exposed the government's illegal surveillance programs. Well, those surveillance programs never stopped. They continued well into Biden, and they really got heavy duty under Obama. Okay, so Barack Obama, many believe that he's a member of the Bush family and that he was groomed by the CIA for his position. And they knew that because he's dark-skinned, that if anybody went against him, they could accuse them of being racist, bigots, and homophobes. And so people would let him violate people's rights. Remember, he's killed more people with drone attacks than anyone in the history of this country, and you never even hear about that. But people flipped out when Trump dropped a couple of strategic bombs on an Iranian nuclear storage facility. So it's kind of interesting, right? How he's still been able to get away with such an overreach against our rights based on these ridiculous arguments of race and identity politics. So it really started heavily under Obama, where there was a DOJ memo that came out that anyone who's white, who goes to church, who served in the military is a potential domestic violent extremist. And because of that, they started heavily surveilling people like me who believe in the Second Amendment, who believe in government accountability. And ultimately, that was exposed by Snowden, that there was an illegal spying program where they were tapping into all of our cell phone data, basically every aspect of our lives, like the movie Minority, what's it called, Minority Project? I can't remember the name now. But what ended up happening is Snowden exposed that. And so Snowden was accused of being a traitor. And ultimately, he had to flee to the only country that would offer him any protection, which is Russia. A totalitarian country like Russia granted him protection from our government. Really interesting, right? Who's the totalitarian government? You tell me. So, because he was a whistleblower, he would have been denied the ability at a trial for treason to be able to argue exculpatory evidence and the motives for him trying to expose this stuff. And we know, and I know from representing whistleblower cops, that once you whistleblow and you go against the thin blue line, for example, your career is over. It's done. You are done. You're finished, and you'll be looked at as a traitor, as a turncoat, and that's just the way it works. So, in any event, moving forward, so under the Smith versus Maryland case, I was really taken aback by this 1979 case because the court basically said, well, phone communications aren't really papers and personal effects. And I'm just paraphrasing, okay? They're not really papers and personal effects in the traditional sense. And therefore, they don't have any Fourth Amendment protections. And the left has tried to do that with semi-automatic centerfire rifles. They've tried to say, well, there were only ball and powder muskets and stuff like that at the time of our revolution. So you're really only entitled to have ball and powder, but the government gets to have machine guns and all this other stuff. When again, the whole point of our revolution, what really sparked it off, contrary to what they teach you in the Marxist run school system, is that the king tried to seize our powder houses where our gunpowder was stored. And that's what really sparked off our revolution against the king, because we, the people, wanted to have the right to keep and bear arms as provided for under natural law, so we can defend ourselves against all enemies, foreign and domestic. But the court system, the statist, government runs courts, have really tried their best to diminish that. And of course, the counter argument to them is, well, since all they had was quills and dippable ink pens at the time of the founding of the country, and they only had parchment to write on, well, typewriters should be illegal. They shouldn't be provided any First Amendment protections, right? So they just make these stupid arguments, and people who went to public schools are so idiotic and incapable of critical skills thinking that they'll just go along with it. A lot of them. Not people on my channel. As you can see, we've only got about 22 people in here today. So you can see that most people just go along with the program. But if this was a story about Long Island audits getting spit on and all that stuff, I'd probably have, 50,000 people here watching the show today. It's just ridiculous, to be honest, where the priorities are in this country. But less than 3% of the population actually participated in the war against the king. So I'm counting on you 3% to get the word out. So when you're at Thanksgiving or Christmas, you can talk about this with your families, all right? Give me a bunch of ones if you like that comment. So, in any event, as time progressed, we have seen law enforcement attaching tracking devices to people's vehicles. And that was upheld by lower courts as being perfectly okay. But I believe it was Justice Scalia who said, no, you can't do that. But even his decision, and I'll give you the citations in a minute when I pull over. Even his arguments were more based on not getting a warrant to put the tracking device and less on the tracking itself, which really bothers me. But anyways, moving forward, just recently the Supreme Court has sort of backpedaled a little bit. And I think it's because of Snowden, by the way, that a lot of this stuff has happened. And said, no, digital communications are just as protected as any other type of communication, especially cell phone site location information, CSLI, because basically the government now has the ability to track you at any time and place of their choosing. Now, just to give you a caveat, that doesn't mean it doesn't happen. It just means that it's fruit of the poisonous tree. So they probably would not be able to use that information to make the arrest or use it against you in court. But they certainly could fly a helicopter around your house, a la Mr. Gold or our friend Reluctant Prophet, tap into you and all your neighbors' cell phones and try to find incriminating information against you. And then try and argue that that is information they could have obtained from another source, or try and obtain that information from another source after they follow you around, and then argue that it wasn't fruit of the poisonous tree when they make the arrest. So the Stingray technology is alive and well, and that's tracking you. It's very easy for the police to set up a surveillance van It's very easy for the police to use a helicopter or an airplane and tap into you and your neighbor's cell phones, which is crazy to me. Look at all your cloud data, look at all your pictures of you and your wife getting it on, laugh about it, share it with their buddies over some donuts and coffee, and think it's funny, make fun of you. Very invasive of your privacy. And there have been court decisions that say they can do that. They can do that. They just can't use it against you in a court of law. But they can definitely use it against you. Hey, what's going on, reluctant prophet? They can definitely use it against you in another way. They can use that data to try and find it from another source. So it's very, very scary, the stuff that they can do. And I'm very, very concerned about what's happening in our country. It's crazy to me that the United States now, in my opinion, has less civil rights and less unalienable rights than a lot of third world countries. For example, I can walk into a pharmacy in El Salvador or Tijuana and get my family some ivermectin or some other kind of medicine, even hormone replacement therapy, without having to go through a doctor to get a prescription, without having to hear some lefty tell me that I have to take some shot or I'm going to be denied my right to travel. Just craziness. So it's definitely happening, guys. It's getting very scary in this country. So I'm almost to the gym. I'm going to pull over and just read some case law to you. By the way, guys, I am attorney Mike Ehline. I've been practicing law for about 20 years, and I am a civil libertarian. Make no mistake about it. I am a man of the people and a man for the people, much to the chagrin of most lawyers and most statists who have been brainwashed in the Marxist-run education system. I am an advocate of homeschooling. I homeschool my kids. I believe in creating parallel systems and growing your own food and homesteading and getting off the government crack. I think that critical thinking is the single most important thing that parents need to focus on with their children. Otherwise, they'll just keep voting for this crap. So I invite all of you to check out some of my videos that I've done with Brett Pike, where we talk about homeschooling and about how to teach our children about critical thinking. And so they don't believe what they see on CNN or Fox News, corporate paid, corporate sponsored so-called news, which is just propaganda. Hopefully, Reluctant Prophet's still here. It's been a while, brother. And look, I've been buried, man. I'm trying to run a law practice, and I'm not getting rich off doing YouTube videos. All right, it's not something that I really make any money off of. Occasionally, I'll get a super chat, or somebody will buy a block of memberships. But for the most part, this is not something that is going to feed my family. So because of that, I get up at like 0400. I'm completely fried and burned out at the end of the day, and it's been really, really hard for me to do lives lately because of that. Me back up and get the spot here. So there's going to be a really cool party at the Powerhouse Gym here in freaking doggone Summerlin / Las Vegas, and I'm going to try to cover some of that for you in a minute. Thanks, Michael Quintana. So just really quickly, so the U.S. Supreme Court has not ruled that there's no privacy in cell phones or internet data due to them not being considered papers and personal effects, at least not yet. But with the FISA courts and all that, we've got all these politically appointed government employees like Peter Strzok and Lisa Page. They got illegal warrants against Carter Page, and ultimately they illegally surveilled Donald Trump. They've done everything they could to prevent him from running for president. So all these political government employees, usually leftists, have done everything they could to violate your rights and get away with it using the FISA courts. And that, of course, was done because our government just allows criminals, crazy people into our country, and they make the country less safe. And then they'll say, hey, let no crisis go to waste. We created this problem where we flooded this country with evil people. Now let's go ahead and take advantage of the crisis we created and pass a law to make it more difficult for you to exercise your unalienable rights. And that's what they do. Give me a bunch of ones if you agree. Hey, you too, Reluctant Prophet. So ultimately, recent landmark decisions have extended privacy protections to digital data. And that's the problem that I have is why do we need a Supreme Court case to extend anything? We have a Fourth Amendment. It's pretty clear. Papers and personal effects. Well, your cell phone is a personal effect. And papers can be interpreted to be digital papers, in my opinion. I don't think it's a stretch. If you look at the hermeneutics, Hermeneutics, it's a religious term, but it has to do with examining scripture based upon its historical precedent, what the words meant at the time, and how they would be interpreted modernly so people could understand it. Hermeneutics. So I'm a legal hermeneutics advocate. And ultimately what happened is a recent Supreme Court ruling under Riley versus California. It's a 2014 case. It was a unanimous decision. And obviously it's people like Snowden that are making this happen, because don't think for a minute that the Supreme Court and other courts aren't looking at public opinion. Okay. Don't think for a minute that they don't look at that. So basically the court unanimously ruled that police generally do need a warrant to search digital contents of a cell phone seized during an arrest. In this case involved a guy named David Riley out in California, and his smartphone was searched without a warrant. All right. So Chief Justice Roberts said that it's not the same as searching a physical item like a wallet or a purse. And I'm thinking to myself, well, that's crazy. Your wallet or your purse are also papers and personal effects. They shouldn't be searched without a warrant either. So I don't like his rubric there. I think that's crazy to me. Now, Incorporeal says cheese is a mass hallucination brought on by government nanobots in our drinking water. The CIA is working with shape-shifting alien lizards to keep it buried. Well, send me some links and I'll cover it, because I'm at the point in my life where I'll believe pretty much anything after the stuff that I've seen. Now, Justice Roberts said that cell phones hold a digital record of nearly every aspect of people's lives. And they contain sensitive data like communications, photos, and financial records, which deserve robust Fourth Amendment protection. Well, why doesn't a wallet deserve robust Fourth Amendment protection? Why doesn't a purse? That's crazy to me. But the court explicitly stated that our answer to the question of what police must do before searching a cell phone seized incident to an arrest is accordingly simple. Get a warrant. Well, no shit, Sherlock. Get a warrant anytime you want to search someone. We, the people, run this country, not government employees. Why did we need a court decision to tell us that? Right stuff, 80. We have the right to privacy anywhere. Our tax dollars created the internet. The Department of Defense used our tax dollars to create the internet. And then Obama turned it over to the European Union. Can you believe that shit? What an asshole. What a total asshole. Oh, you didn't build that. Someone else built that. Right. Go F yourself. Barry Sotero, Bathhouse Barry. What a disgrace you were to this country. So this particular ruling in Riley versus California established that cell phones are not just physical objects, but they're repositories of vast personal information, warranting heightened privacy protections. And the court dismissed analogies to physical searches, noting that comparing physical data, strike that, digital data to physical searches is like, and this is Roberts, again, another crazy analogy that doesn't make any sense, like saying a ride on horseback is materially indistinguishable from a flight to the moon. But I don't think it is. We have the technology to hop on a rocket and go to the moon. I don't see that it is distinguishable in any way. I think indistinguishable. And I think that getting on a rocket, getting on a horse, the rocket's the modern horse. Give me a bunch of ones if you agree. So now Carpenter versus United States was a 2018 case. And this was a 5-4 decision. And this is scary because now we're getting into the left versus right paradigm. where it used to be when I was a Democrat, the Democrats were all about protecting the privacy of individuals, the whole hippie community. That's what it was all about. So now it's shifted because of corporate America buying politicians off who appoint these judges, right? Political appointees. So in that case, a 5-4, very slim margins here. The court ruled that the government generally does need a warrant to access historical cell site location information, CSLI, which track a user's movements over time. The case involved Tim Carpenter, whose location data was obtained without a warrant to link him to robberies. Chief Justice Roberts, writing for the majority, held that individuals do have a reasonable expectation of privacy in their location data, even when held by third parties like phone companies. So this sort of changed the paradigm of Smith versus Maryland, which really pissed me off. I hated Smith versus Maryland. I thought that case was wrongly decided. So I'm grateful at least the Supreme Court, I believe under political pressure, sort of changed their tune a little bit. But the court limited the application of the third-party doctrine from cases like Smith v. Maryland, 1979, which found that tracking devices to a suspect's vehicle without a warrant, wait, strike that, which found there were no privacy expectation rights to tracking devices on a suspect's vehicle without a warrant. And so the majority opinion written by Justice Antonin Scalia focused on physical trespass of installing the device, but also acknowledged privacy concerns, but didn't really get into the privacy concerns. It got more into whether or not you needed a warrant, which is bothersome to me. So ultimately, Justice Sotomayor concurred in that case, and she highlighted that digital tracking could chill associational freedoms and suggested rethinking the third-party doctrine in the digital age. Well, there shouldn't be a third-party doctrine at all, guys. Your data is your data. It is your personal effects and papers, and that's why I do support the concept of a third party, because a third political party, because I think that both parties are just bought and paid for by corporations, and that's why I don't take sponsors at all. So I may take a homeschooling sponsorship or something like that, but that's about it. So while narrower than Riley or Carpenter, this case signaled the court's growing concern about digital surveillance and its impact on privacy. See you later, Ivan. Go back to CNN and listen to your Marxist buddies over there. We don't need idiots like you on my channel anyways. So basically, whether or not the Fourth Amendment protects against unreasonable searches and seizures of persons, houses, papers, and effects, it's still kind of up in the air in the modern digital age. But the Supreme Court has at least recognized that digital data on cell phones and internet-related information like CSLA can fall under this protection. Gee, thanks. And the key points of this case are that in Riley and Carpenter, the court acknowledged that cell phones and digital data are an integral part of modern life, holding that the privacies of life that the Fourth Amendment aims to protect are sacrosanct. What's going on, Jonah? Chief Justice Roberts emphasized that cell phones are such a pervasive and insistent part of daily life that their data requires protection akin to traditional papers and effects. Why did we need a Supreme Court justice to tell us that, guys? I mean, honestly, isn't that crazy? I mean, you don't think for a minute that your rights aren't protected under the Fourth Amendment just because it went digital? Just think what they were trying to do with digital currency. I mean, the left was doing everything they could to create a centralized banking digital currency like they have in communist China. So they could just shut down your bank account if you didn't agree with some politician that women can be men, for example, like they're doing in Canada, or you refuse to take someone's shot, for example. So now the third party doctrine has been limited in cases like Smith versus Maryland, and that basically had to do with phone numbers that were dialed and stuff like that. However, Carpenter clarified that this doctrine is less applicable um, to modern digital data due to its qualitatively different nature, such as comprehensive location tracking enabled by CSLI. So digital versus physical, then we'll close it out. That's right. Until you go to the border, we're gonna get to that in a second, Bob Johnson. That's an absolutely amazing observation. Good seeing you, Mr. Osgood. So the court has rejected arguments that digital data lacks privacy protections because it's not a physical paper. You too, Jackalope75. I hope your day goes well as well. In Riley, the court distinguished digital searches from physical ones, noting that the vast scope of personal information on phones is protected. In Carpenter, it extended this logic to data held by third parties, ensuring privacy rights adapt to technological advancements. Gee, thanks. Gee, thanks, Your Honor, for growing a brain cell. I appreciate that. Now, the Riling and Carpenter rulings are specific to cell phone searches, incident to arrest, and historical CSLI, respectively. So they don't broadly address all internet data or other digital platforms like social media or cloud storage, right, guys? That's why I have a problem with the cloud because there's no decision on it yet. So the court has not yet ruled on any of that. Now, both rulings allow warrantless searches in emergencies. They call that exigent circumstances. So while Carpenter limited the doctrine's reach, it still applies to less sensitive data like bank records and phone numbers. So that's kind of scary that they could just get your bank records. That's pretty wild. That's another reason why I support cryptocurrency, man. Why on earth does the government have a right to know how much money you make? Right? Why do we even have an income tax? Doesn't that violate the Fourth Amendment that you basically have to give up your right to be secured in your papers and personal effects? Think about that for a minute. So future cases may clarify, but I doubt it because they're going to put their political appointees on the bench. Now, the court has declined to take up many related cases like warrantless searches of travelers' electronic devices at borders. So let's flood the country with 20 million illegal aliens, make it less safe for the American people, right? But open everything up to searching everyone's phones at the border. Come on, guys, give me a break. So by them not taking up the case, they basically are saying it's okay. That's my interpretation. So in conclusion, the U.S. Supreme Court has not stated that there is no privacy in cell phones or internet data due to their non-physical nature. But on the contrary, in the Riley versus California case, the 2014 case, and the Carpenter v. United States case, 2018, the court has affirmed that cell phone data and location information are protected under the Fourth Amendment, requiring warrants for most searches, but not all. That's what's scary to me. These rulings recognize that digital data, while according to the court isn't traditional papers and effects, holds deeply personal information deserving of constitutional protection. Thank you, Your Honor. I appreciate that. However, they still haven't decided that broader internet data like social media and cloud storage is protected. So they're less defined in future cases, may or may not shape this evolving area of law. But if you have specific scenarios, social media, or real-time tracking stuff you want to talk about, let me know in the comments and I'll do another show about that. So what I'm going to do really quick, guys, let me secure my firearm first, lock everything up, and let's go ahead and see if there's anything going on. There's supposed to be a little shindig here. It's supposed to be a little shindig here at Powerhouse Gym. Give me 1 second. Got to get ready for my workout. And I'll take the camera with me and we can get a little look see at what's going on, all right? Just give me 1 second. All right. Unfortunately, I'm using Restream, so it's hard for me to flip the camera around. So I'll point it in the general direction of what's going on. I don't think the party started yet, so we'll take a look this way. All right, here we go. Yeah, it doesn't look like a whole lot's going on yet, but you see there's some cool cars over here. Well, it's hot, man. Let me lock this bad chicken up. So it looks like there's a, they're going to have it catered. Here, let me give a shout out to the catering company. Looks like it's called Real Prep, Meal Prep, Meals to Fuel Your Goals. I'm all about that. Party time. That's right, man. Let's check out some of these cool rides. All right, so we got this pretty badass Bronco over here. It's pretty sick. This Ram looks pretty sick. 6.2 liter supercharged. That's pretty wild. Got some cool rides over here. Check it out. Hell yeah. So it looks like it's like the 6th anniversary or something of this gym. This is Powerhouse. I always try to get my workout in on the weekends. Pretty cool bends. All right, let's take a look. So it looks like they're just setting it up. Take a look here. Looks like it's like either a 6 or a 4. I'm not quite sure. But it's an anniversary. Oh, go ahead. Some kind of an anniversary. So this gym is owned by Iris Kiley. She is a 10-time Miss Olympia, and she trains my wife. My wife is into fitness. She looks amazing. Tell you, ladies, if you want to keep your man around, just stay hot. Doesn't matter how old you are. Just keep yourself in shape. All right. So Johnny Five, I appreciate. No, it's not. Bruce, this is I believe it's the 4th anniversary of the Powerhouse Gym in Summerlin. These guys here, not Summerlin, but Las Vegas. So there's just some cool cars out here. Looks pretty sick. Let's check out this Ram TRX. This looks sick. What do you guys think? Yeah. So I'm gonna go hit the weights. Here, I'll take you into the gym really quick before I go offline, so you guys can check it out. Guys, ready? How's it going? Looks amazing. Just trying to check in here. Check it out. Oh, thank you. Say hi to everybody. We're live on YouTube. Freebies. Nice. Oh, raffle ticket? Yeah, it's around 12 o'clock. 12 o'clock. Awesome. You need to be here. All right. Thanks. How's it going? I'm on YouTube with my buddies. YouTube. Yeah, yeah. Say hi to everybody. So 4th anniversary? Yes. We're re-streaming on YouTube. I got like 60,000 subscribers. Yeah. The judo channel. What? The judo. Well, I do judo on this. I film my son on YouTube. No, I'm a lawyer, so I do stuff about law, but I always tell everybody, especially lawyers, they need to get into the gym and work out because of all the stress. So here, we'll just kind of cruise around and take a look over here. What do you guys think? It's pretty cool. Wow. Hi, Iris. How are you? I'm live on YouTube. I got like 60,000 subscribers. I'm trying to promote your party for you. Yeah. You guys come join us. This is Iris Kiley. She's 10-time Miss Olympia. 10 times, give us a pose. Yeah. Check out those guns. Hell yeah.
Where's the family?
Unfortunately, my wife had to work at my son's store.
Oh, okay. Oh, good. Now you know
But I'm
you.
going to try to get him to join.
Okay.
All right.
20% off.
Well,
Seven.
oh, man.
Just today.
Just today and today only.
20% off the membership. The lowest ever since we opened. So come on in and join Powerhouse Gym.
Get over here, guys.
Real locked in and grandfather your prices in.
Make it happen. So you guys can kind of check it out. Pretty cool gym. Just kind of give you guys a little look-see around. Pretty big gym. A lot of good stuff in here. I'll cruise around here. Let's check it out. Chili time. That's right. I'll take you into the rest of the gym here, but you can kind of see a lot of good equipment here. Got all the Mr. Olympias up here on the wall back here. See them up there. Party time. Smells like chili in here. So this is all paleo style food here?
This is all gluten-free, no refined sugars.
Hell yeah. Gluten-free, no refined sugars.
Protein desserts and vegan options.
And this is you right here?
Yes.
Fit for life. Okay.
Like dessert.
All right. I'm just showing my YouTube guy. I got hey, give us a plug. Got like 60,000 subscribers on this channel.
Oh, really? Fit for Life Desserts. Gotta come follow us. Best desserts, healthy options, and no guilt.
Guys hear that? Get your butts out here. Get to the gym. All right. So that's pretty much it, guys. I'm going to go ahead and close it out. I got to get a workout in, guys. I'll talk to you soon. Make sure to like and subscribe. Make sure to save because we never know when the thought police are going to take down this channel. Talk to you guys soon.